You're listening to Explain That by Velocity Legal, the podcast that keeps business owners and professional advisors ahead of the curve in an ever-changing legal landscape.
Blended families are a common family structure in Australia. They bring a set of unique legal challenges when it comes to estate planning. In this episode, we will dive into the complexities of ensuring that your estate plan reflects your wishes while balancing the needs of the whole blended family. Today, I'm joined by Director Jennifer Maher from our Trust and Estates team and Elisha Raucci from our Trust and Estates team, who's a Senior Associate. Firstly, welcome to the podcast. It's our first Trust and Estates episode.
One of many to come, Andrew. Thank you for having us.
Yes.
And firstly, before we get into it, it's timely because I wanted to congratulate the team on the Doyle's Guide's recognitions for estate planning and estate litigation. That must be huge.
It's a very proud time for our team. We're very humbled. It's peer voted, so that means we're recognised within our field as doing a good job, and we hope that translates to clients and our client service.
Fantastic. All right. Well, today we're talking about blended families. Now, when I was sort of thinking about this, I know people throw it up, the Brady Bunch. This is going back a long time, well before any of us were alive. But, that was a very unique situation where you've got, kids from two different marriages and they come together into a family. But that's very common these days, isn't it?
It's more common than not.
Yeah.
It's very rare, I would say, these days in the estate planning context that we see a vanilla mum and dad who have stayed together for 30, 40 years, assets are jointly held, and there might be complications with the children, but in terms of that blended environment, the multiple entities, the varying degrees of complexity that we need to deal with and that balancing act, it's more common than not.
Yeah. Well, before we get into the nitty-gritty of the blended families sort of pressures, I guess, Elisha, maybe you just start with, what's your sort of conventional 101 sort of nuclear family kind of approach?
The main normal issue is, in terms of blended families, it's usually not understanding how the asset ownership can impact where that goes and what happens, and then potentially not passing in the way that they intended or what they would like to protect for children of a previous relationship. I think that tends to be the biggest starting issue that we come across. Because I guess
in your nuclear kind of family, the non-blended family, it's a bit simpler because it's typically unless Jen, as you said, there still could be considerations, but unless there's something out of the ordinary, it's usually sort of to the spouse and then
everything to each other.
To the children all jointly.
Correct.
But how do you deal with that when, you're balancing on one hand, different children, and maybe some of them adults, some of them are children, and then a spouse as well?
Yeah, and often with some of the blended families that we see, there is this significant age gap between adult children of the first relationship or the second relationship and what that might look like with that third or fourth spouse. There's no time frames on how many times you can actually re-enter or repartner and have children. And so sometimes that age gap, I had a matter where there were 6 kids, and that they were adults. One was a lawyer practicing, so 45 down to 6. And so it's a very difficult situation to say, well, what is the asset pool that we have available to us? What are the risks in terms of who might challenge? What are the family dynamics? And how do we carve out potentially insurances or super to quarantine those to, the bloodline children and not sort of put it into a pot which might be exposed to a family provision claim?
And I was going to ask, how do you sort of start those conversations? So say, a client comes to you, they've got a blended family. How do you start those conversations?
It can be awkward sometimes if they haven't had the discussion pre-meeting, but usually the first question is, what's your overall objective? What is your intention? What would you like to see happen? That normally then frames the basis for the advice that follows after that. So Jen already touched on it, whether we're segregating certain assets for certain children.
Yeah, and I guess once you take those sort of instructions on roughly what they actually want to do, it's assessing, I guess, the legal risk of those actions, how to avoid those risks.
And I usually start with a family tree, to be honest. Put it on paper. It's a visual sort of cue, and it helps you then when you've got the assets to say, well, that's going to go that way and that's going to go that way, and how do we make it work? It just helps that thought process, because often it is the primary concern, and sometimes there is a conflict that we have to say we can't advise both parties, because sometimes that concern is the discussion they've had is just in relation to their current spouse, but there are really significant competing needs with their first spouse, whether it's an unresolved family law issue, which again happens. There's no, like I said, issues with timing. You can repartner at any time, and sometimes people do in that divorce situation and they've already repartnered. And so there is then again another layer of concern and litigation that we need to factor in. And so from that perspective, sometimes that mud map is good, and then sometimes it is that difficult conversation to say, okay, well, you two might have been on this page, but now I actually have to introduce a new concept.
Yes.
And that's sometimes a little bit awkward.
Yes.
Where you say, no judgment, but,
Yes.
that your children and this child, they should not be treated equally, but you can't dismiss that there are other children in this, family tree.
I guess sometimes people, they ask. Well, sometimes people don't even do estate planning, and of course
Yes,
that would
that's
be
true.
shock horror, but it's a reality. I wanted to ask, sort of at a very high level, what would happen in a blended family type situation, Elisha, if someone was to pass away just without anything done?
Yeah. So if we presume potentially assets are jointly held, it would automatically pass to the surviving spouse. So children would miss out at that point. With sole personal owned assets, the legislation sets out who benefits. So the spouse in effect would get majority, and then there would be some provision for the children of the previous relationship. But sometimes that split or the type of asset passing in that manner is just not what they would have wanted to have happened.
And I think too, bear in mind, the legislation does provide for the fact that you can have a spouse and another partner, so multiple spouses at the one time.
Okay.
And so just flagging that because people do live that way. And so then it's a delicate, decision and talking through to say, well, you actually do have two spouses at this point in time.
Yeah.
And you do have children, and sometimes they're not children of those relationships. And you do have that sort of then assessment of, wow, this is a really serious situation. What do we do with that? And from the legislation perspective, if there is no will, you have competing claims on foot to who should administer the estate, which will then indirectly potentially impact upon who will receive and who will challenge. And then
it becomes more costly because the risk is higher and normally becomes litigious. So it becomes far more costly from an estate perspective than just having it all sorted.
Yeah, that's a good
lifetime.
point. So, not only is it sort of taken out of your hands in terms of who gets what and based on sort of legislation that may be completely different to what you want. But in addition, what you said, Elisha, is that, well, who's actually going to be the person who's the executor, and there might be a fight over that. I guess maybe let's just touch on briefly, when things go wrong. I mean, what I don't want to hold you to figures and things like that, but, how bad can it get?
It can get bad. I mean, Jen, you've probably had a lot that have probably hit the hundreds of thousands when it gets really bad.
Yeah.
I think in general, you're looking at least, let's just say 60K alone with legal fees. Then you've got barrister fees. Then you've got the other side. Potentially the estate may need to pay all of it. So it does get expensive. And also the strain on the relationships between everyone as well is not something to completely disregard.
Yeah, it's exhausting on
can't quantify that.
Yeah, you can't.
Yeah, for the sake of getting it right up front. And I guess you would often ask those sort of harder questions of clients and say, I don't know, well, how does this play out? What about this?
Yeah, and particularly where you do have, and I've had this situation, I'm sure you have too, where you've got a younger couple, but it is a second couple, and they all have young children. And so that, husband, to me, just for the purpose of the example, has 4 children from the current relationship to the former relationship to, they're all under 10. Do you know what I mean? You've got serious competing needs with, they still need to be educated, so do your current children. And so, and the spouses might not all get along. I mean, I've had some beautiful success stories where they've really worked collaboratively.
Probably
and they
more rare.
are the Brady Bunch.
Yeah.
And it is lovely. They all go to the weddings and the birthdays, and I say credit to you for being able to navigate that and achieve that. But where you do have those sort of serious competing issues, the strain on the relationship, if that middleman is gone, so to speak, between the two spouses and then the children, everyone's grieving. And everyone needs funds, because sometimes that middleman is the person who is the primary income earner because they've got young children. And so it's a very difficult task to say, well, how do we work this out? And if you don't have a will saying here's what's going to happen, it can get very hostile.
Yeah. Well, let's maybe delve into, I guess, some of the sort of mechanisms that you might sort of look at and chat with clients in those blended family situations. My very basic knowledge, I know sometimes it will be, the spouse will get the sort of family home. and then other things will go to the kids split evenly. Is that pretty common that you'd start with? And would it be a life interest, or what are the issues there?
Life interests, I find, are useful for a limited purpose, and I'm probably the exception in the rule, and I think Elisha's the same in terms of our views with estate planning. They were quite common historically to use, but again, the differences in the ages between the relationships and then the adult children, there's no point having a life interest for a second spouse when she's almost the same age, slightly older than the adult children. Potentially the adult children will never receive a benefit because she will live for as long as those adult children.
Yeah.
And so I think it does require more of an analysis around what do we need to achieve now.
Yeah.
And stepchildren as well can sort of contest a will. So it's, again, moderating that sort of environment and that dynamic. It's around looking at, we're not family lawyers. We don't make an assessment of contributions. But we do need to recognise, I think, and advise our clients, well, if it is a blended family situation and there are these contributions from this person and contributions from that person, do they respectively go back down that line? And so sometimes it's I don't even know if I answered your question.
Well, to touch on that point, it was a good answer. To touch on that point, stepchildren, now, are they eligible to make claims if someone passes away?
They are.
Yes.
It's the short answer.
Yeah.
It's tougher it's not tougher, it's more difficult for an adult stepchild to challenge because they have to, essentially be able to persuade the court that they can't provide for their own reasonable means, that there was some element of financial dependency. And so and they need to have that continuum of the relationship with that step parent on the death of their biological parent. All of those factors are directly relevant. But if that sort of, if we use the sort of situation of everything goes from one to the other and then that sort of biological family misses out, there's a significant argument to say that there were assets contributed to that estate and they should have come back out. And so sometimes, we do have that concept of the mutual will agreement, which, I don't particularly use that often. Because I find now the mutual will agreements are going to become more and more like a financial agreement in the family law perspective. They are a contract that you cannot change your estates, but they need to be very well drafted because they are a contract. And so they can be quite restrictive because you can't, divest your assets. We're restricted in how we can use them as the surviving spouse. And that's why, in terms of the analysis of doing a mutual will agreement, they are useful and successfully useful. In very limited circumstances.
To a limited extent, because you can try and capture as much as you want. So I'll use superannuation as an example. There can be a strong argument of, well, was the intention that superannuation was meant to form part of the mutual will agreement, but if it doesn't specifically provide for it, and then you're trying to balance that with, well, the surviving spouse will have needs, medical expenses, might need to rehome, so how much do you restrict it? So they do need to be drafted extremely carefully, but at the end of the day, it's creating an enforceable contract for the children to say, well, you breached that, but it still needs to achieve a purpose and be within reason. So I don't use them that often.
And correct me if I'm wrong, a mutual will is essentially the two spouses will sit down and do essentially sort of like mirror wills, but have this sort of contractual agreement that one won't change it, which is, I always thought it was good. Good that I'm right. I always thought it was interesting because it's, the normal principle is you can change your will at any time.
And they still can. So they still can technically create a new will, and it's, as long as it's executed correctly, it's still a valid will. You're creating a contract that potentially the children that surviving spouse removes, they can then say, well, you sign this and you've circumvented it. It's contractual rights and obligations, but you can still create as many wills as you want after date of death, and they will still be valid.
Oh, really interesting.
And I think that's where the point of sort of the financial agreements in a family law perspective require independent legal advice. And I do think in the next 5 to 10 years, with the complications in blended families, the different entity structures, we will have that situation where if we do a mutual agreement, I would be saying to the other spouse, go get independent legal advice just to make sure it's valid and binding.
Well, you've just touched on two different things that I want to explore now, other entities and superannuation. Let's start with family trusts and talk about those a little bit. I guess what are the considerations for blended family situations with family trusts?
It depends on the purpose of the trust and why it was established as well. So what we see often is that the trust will be an older trust that was potentially created during the previous relationship, and there was a clear intention that it benefits the children of that relationship. So, and the assets remain in that trust and don't pass via that person's will. So what we're normally looking at is, what's the overall intention? Who did you intend for that trust to benefit? And continue it on that basis and not do too much to change that, but come up with other avenues, potentially establish a new trust.
Yeah,
for
so
example,
blended family set up. So trust set up a long time ago for the children from the first marriage, let's say. Yeah. And you're saying, look, should that be kept as is, essentially not disturbed too much, or, you know?
And I think it does, again, devil's in the detail. You need to make sure that the beneficiary class is who you intend, but also the control of that is really important, because there's no point quarantining out that trust for the benefit of the biological children if you're then potentially going to put in the second spouse accidentally or unintentionally in control of that trust, because again, you've got a dynamic where you're going to have a potential risk of conflict. And if the children do fall within the class of beneficiaries, you might have a situation of that second spouse preferring their own children opposed to the intended children of that trust when it was established.
And there's a potential for the spouse to automatically step in and control the trust if the deed's not looked at and reviewed as part of the estate planning process. So,
a question I wanted to ask, Jen, how often have you seen a will try to deal with trust assets as part of the estate?
Unfortunately, too often. Will be the short answer.
Yes.
I don't recommend it.
Yes.
I must say. And I think, just touching back on the trust issues as well with the beneficiaries, read the deed is always the mantra with any family trust situation. I had a blended family situation where she was the third spouse and had the youngest of the 6 children. And as a widow, she inherited control of the family trust, but she was an excluded class because widows were excluded.
Okay.
So she couldn't even benefit or pay benefit to herself in that situation. And had someone read the deed when they were doing the estate planning, they might have realised that. And so my client came to me saying, a lot of the money is in this family trust. And I said, you can't pay yourself. Yeah. I'm really sorry. Yeah. So, thorough review is entirely important.
Well, let's turn to this super topic. And Elisha, I know you've got expertise in superannuation, so I'm going to direct the questions to start with at you. But I know there's been all sorts of cases and disputes in blended family situations about when the individual's passed away and the fund, and there's a dispute about basically where the super goes. Yes. Can you sort of enlighten me a little bit beyond that basic knowledge of what the issue is here?
Yeah. So as a general principle, superannuation does not automatically form part of someone's estate. It passes in accordance with the binding death benefit nomination. So if your intention is that it's meant to form part of the pool of assets, you would normally direct that to the estate to be divided as needed. If there's no nomination in place, you're allowing some discretion to be used about who benefits. Generally, the spouse, because they are tax dependent, it's a tax-effective manner of passing the superannuation. So that's normally the decision that would be made. And if I use externally managed funds as an example, you're relying on someone that you don't know to make a decision about who they intend to pass the superannuation to when you pass away. And normally the box is being ticked that it's effective to pass it to the spouse. They can confirm they're a spouse, which includes the de facto partner as well, and pay it to them, which may not be what the overall intention was with the division of the assets, and then that can turn into a potential dispute surrounding the super. With self-managed super funds, it's a little bit different. Normally the executor steps in to manage it, but that's also important because if your executor is the surviving spouse who's your second, husband or wife or third relationship, they're in effect exercising a discretion to pay it to themselves, and some of the cases surround that, in effect acting in a conflict and misuse of that power, and not following turning your mind to other beneficiaries and why minor children are tax dependent. You could make a decision.
It's a really interesting area because, I think a lot of people would have thought, super sort of there isn't that discretion there. But as you said, if it's a public fund, it's someone external that has, unless there's a binding nomination, someone external's ultimately got that discretion on who to pay it to. But then in a self-managed fund situation, someone probably who has a stake in it actually is the one making the decision.
Exactly.
That's really interesting.
Yeah.
How do you what do you normally sort of, is it normally like an education piece with clients on the superannuation side?
It is, and getting them to understand the importance. So if it's a self-managed super fund, reviewing the deed, seeing who's going to step in, making sure that's who you want to step in, and ensuring that any nomination that's prepared is in accordance with the trust deed and the terms and what it permits, ensuring that you can do a non-lapsing nomination so it doesn't inadvertently expire after 3 years, which is still common in a lot of deeds. So it's about getting to understand, and a lot of wealth is in super. It's still there. It's generational. So it's about ensuring that that is, in effect, protected to the extent of passing to who you want it to pass to. And then I've got an example of an external managed fund where his intention was that the superannuation passes to the estate because one child was not good at managing money and we had trusts in the will. So the intention was that the superannuation forms part of the trust and they were well and truly adults as well. The fund tried to push through the nomination as being invalid due to it not being initialed correctly. So there was an error on the date. And one of the witnesses didn't initial it. Luckily, I had a letter from them confirming there was a valid nomination in place, and then they tried to backpedal after that. So we got it through, but it would have completely unravelled the intention. So the other important thing is, from an externally managed fund point of view, is we do prefer to sign and witness the nominations in our office, send them off to the fund ourselves. And if there's any issues, we can follow up with the fund, but it's about just making sure that it is in place validly.
And that's a great point, that just the consequences are so high in this area for if you stuff something up. And it's really interesting because a lot of areas of law, there's DocuSign, there's electronic things, but, I see you both, shuddering.
Dinosaurs. We're dinosaurs.
We're the last bastion of a wet ink, signature on most of our documents.
Yeah.
But the consequence of that will document are so high, and you want it to be foolproof and bulletproof. So
the control.
I get that. Yeah.
And I think touching on the super too, again, in the blended family situation, which is usually on a higher rate for us than ordinary, is the power of attorney document. Because the power of attorney document, if you take a default perspective, second spouse will be the financial controller and power of attorney. Potentially they can renew or sign a different super nomination. And so in our power of attorney documents, again, it's that bigger picture situation of, well, do we want to enable that power or not? And so it might be carving out, like, my attorney cannot change my super nomination because we want it to be hardwired.
Correct.
We want it to flow the way it flows.
Yes.
Or we might say, depending on the superannuation provider, because they're all different, it might say they can renew but not make a new one. So we're allowing it to be renewed. And so, again, making sure that the
limit the power to follow it.
Absolutely. So it doesn't, again, undo the apple cart unintentionally.
The power of attorney are really important. We haven't spoken about them until now, but they are such a big piece of the puzzle as well, aren't they? Because we talk about someone passing away, but the reality is they're probably, a lot of cases, people have a period of incapacity between before death, and the will doesn't govern those type of situations.
No, and it's important too, if you're doing a life interest, for example, or providing, even if it's a child who's occupying a home owned by that donor, you want to make sure that their intentions are mirrored in the power of attorney document. And I do think a power of attorney document is a very undervalued document as part of the estate planning tool, because what we don't also want to happen is that a piece of property, for example, that's going to be gifted to a beneficiary or that's going to be the subject of a life interest is sold to fund an accommodation bond or something like that, and then we've got a failure of a gift. And so I often, and I know you're the same, if there's anything specific of that nature, particularly in a blended family context, we will hardwire that in the power of attorney document.
Yeah, That's the importance of planning and getting sort of the holistic approach and understanding all the, the will, the powers of attorney, the trust, the superannuation, and getting everything speaking to each other rather than, piecemeal.
The domino has to fall the right way, as I describe it. I'm like, okay, look at the domino effect.
Yeah.
And that's why I do mud map and I do draw diagrams for clients, because it helps them go, oh, I can understand where it might fall over. And so, the value in the detail in our documents is realised by clients when you can talk to them and say, well, this is a great idea, but implementation will be, needed to be able to make sure it stands.
Yeah. Well, I think you've both shown, I guess, the value, and what we've been discussing is really the value that a legal professional who specialises in estates and trusts can really provide in these more complicated blended family situations, which aren't that uncommon. And as you said, the dominoes, do they line up? Is it going to fall the right way? Asking the right questions. You've really shown the importance of that in those type of situations. Let's say I'm an advisor or a potential client, and I've got a blended family situation and I'm wanting to engage on that. What's the sort of your normal process look like?
First step is an initial meeting. We normally do get some information prior to the meeting from the client, but that initial meeting is key because it's where you can sit down, discuss exactly what they would like and give some advice and recommendations in that first meeting. So that's step number one, is meet and discuss what they would like to do and what we can do and how we can assist.
And then you're putting in place a plan from there?
And I think if it's come from an advisor or a referrer, we would like that advisor or referrer to be a part of that initial meeting too, because often they'll have the detail in terms of the financial aspects and positions, and even things like a member account balance. They will have that at their touch point rather than the client being able to say, I think there's about this much. And so I think that's the first thing too, is to say clients, and if they have an advisor and it's come through the advisor, more than welcome to come in. We'll have that high level discussion. It might be we need further documents, the detail to review the trustees or the self-managed super fund, and we'll do a plan. So it's the plain English version of the will, because sometimes they will be more complicated. The plan will be circulated, that's our working document, and then we'll do the detail in the final drafts. And then the plan, I say to clients, every tax year, every time you do your tax, look at your plan and make sure your estate planning is still appropriate. You usually don't have to change it sort of every 3 years, maybe if there's a new child, new relationship, potentially, or a separation. But every tax time, do that legal health check for your estate plan.
Yeah, I think that's a good suggestion, and having that sort of living document that's less in legalese and more in plain English is very important, so that people can check and reflect on that. I wanted to thank you both for being part of this episode, and I encourage any listeners, if they have any trusts or estates questions, to reach out to Elisha and Jen. Thanks once again.
Thank you.